Let me invite government officials to come in. This is Bills Committee meeting on Statute Law Miscellaneous Provisions Bill 2014. This is our second meeting. In the last meeting, we discussed parts 7, 8, and 9. Today, we will discuss parts 2, 3, and 4. Let's welcome 9 government representatives from 5 departments attending today's meeting. Many meetings take place at the same time, so many members cannot attend the meeting. So who is going to take us through part 2? That is amendments in relation to sexual offenses. I'm from the Security... a representative from Security Bureau will be responsible to brief members. Mrs. Kong? Thank you, Chairman. Let me briefly explain the amendments in Part 2 and also the background. In Part 2, basically, we are talking about the amendment to the Criminal Offence Ordinance, and 5 provisions will be amended, 118C and 118H. So the legal age for sex behavior for male will be amended. And then 118C, F, and J. These 3 provisions will be deleted according to the court ruling. In 2005 and 2006, after the court ruling, these provisions have lost their legal effect. The police and the Department of Justice had not made any prosecution or taken any prosecution action on these provisions. Another point is that LRC in 2006 set up a subcommittee on review of sexual offenses. In 2005 and 2006, the court made rulings. And this subcommittee on review of sexual offenses will do a comprehensive review of sexual offenses in Hong Kong as well as related legislations. Now the review is underway. At the end of 2012, they issued the first consultation paper. Now they are drafting the second one. For this review, the important part of this review is that there are a few guiding principles. When this review is underway, the guiding principle is that there should be respect for autonomy, and there should not be a differentiation of gender, and there should not be differentiation on sexual orientation. So representatives of the legal sector proposed these amendments. Because the LRC review is underway, but they may take longer time. So the legal profession had reflected to us and the DFJ that we should not wait till the review is completed before amending these provisions. They're of the view that amendments should be made ASAP. After discussing with DFJ, we agree that when LRC continues its review, we should at the same time try our best to amend the unconstitutional provisions as soon as possible to reflect the court's ruling. This amendment proposal, based on a two-pronged approach, is such that we will make technical amendments and the LRC will conduct a comprehensive review. So there's the LRC Review Committee, EOC, and also the Committee on Elimination of Any Discrimination on Sex Basis. And the related organizations and bodies support our approach. So the LRC will continue its review, and we will also make amendments as soon as possible. That's all. Thank you. Thank you, Chairman. Members, any questions? Mr. Chan Chi-chun. First of all, I would like to say that finally the administration is willing to make amendment. This is ruled as unconstitutional in 2005. The administration said they would do it ASAP, but then we have waited for 9 years already. Because the law is not clear, many male homosexuals don't know their basic rights. They don't know the age of legal sexual behavior between males. Now, according to court ruling, it's 16 years old, but today many people still don't know. They thought it's 21 years old. So I think that we should deal with this issue as soon as possible. Besides, not only are members of the general public not in the know, many law enforcement agency people don't know. They enforce the law based on 21 years old. So I hope that this is the last time I'm making this point. There are people who are over 16 years old. They are male homosexuals who can engage in legal sexual behavior. And I hope that they won't be prosecuted. Now, this amendment is only related to the part that is ruled unconstitutional. If we look at amendments related to sexual offenses, now if we resort to common sense, there are also other provisions that will be unconstitutional if there is a JR. So first of all, I hope the administration can explain very clearly that at this stage or under this miscellaneous provisions bill, are you only handling those points ruled by the courts? There are other things that are in conflict or that are contradictory to one another just by resorting to common sense, and you cannot work on those. If that's the case, when can you do it? Not only this issue of age is not proportionate. If you look at penalty, well, it's a lifelong imprisonment for male homosexuals, but 5 years for male and female sexual behavior. So I think this is an inequality in the law. And if you look at actual cases, well, we have looked at some statistics, 9 months to 9 years for male homosexuals, and 54% of them were sentenced to immediate imprisonment. So for sexual intercourse between underage, 3 months to 6 years, and 11% of the people are sent to prison immediately. So 1 out of 10 of the convicted was sent to prison immediately. So if you look at the penalty and the actual law enforcement, there is inequality. So if we are to review the law based on the equality principle, then it seems that only half of the law is amended. Besides, 118G, HIJK, in these parts, there are provisions on serious obscene behavior or inducing others into sexual intercourse. But then there is not corresponding offense in heterosexual behavior. So I would like to know why there are these provisions that will maintain an inequality in sexual orientation. Thank you, Chairman, and thank you, Mr. Chen, for your concern. Let me give a response. Thank you, Mr. Chen, for supporting us to make this amendment as soon as possible. During the consultation process, Mr. Chen reminded us already there may be some police officers who don't quite understand the provisions. There are some internal circulars in the police that these unconstitutional provisions should not be enforced. But in some individual cases, the police officers may not fully understand the situation. So we have to thank Mr. Chen for the reminder. In fact, the headquarters, the criminal headquarters of the police had asked various formations and police districts to remind the frontline officers. Frontline law enforcement officers must not enforce these provisions that have been ruled unconstitutional. Now, the police had already briefed the senior police officers according to our instructions or guidelines. As regards other provisions mentioned by Mr. Chen, there are 5 provisions being ruled as unconstitutional. And if you refer to 118, there are other parts that involve offenses of male homosexuals. We do agree that this is not desirable. There was this ruling back then, and the then Secretary for Justice immediately asked the LRC to do a review. Now, we agree that the provisions targeted at gender and sex orientation, and this is not desirable. And if we refer to criminal offense ordinance, this is a structural issue in nature. So we cannot just make amendments to a couple of provisions to handle the situation. We have to do a comprehensive review. As said just now, the LRC, because of this, will not differentiate between genders in their review. Now, there may be provisions about assaulting small girls, but then not young boys. So I think we have to look at these as well. These topics are of concern to the public. There must be public consultation and discussion, and that's why the LRC review is important.
As I mentioned earlier, for the police enforcement and also for prosecutions made by the DOJ, these have to be very carefully carried out. And where there are such cases, as for J, the Secretary for Justice's officers will have to be consulted before any actions should be taken. Now, as for penalties, this is also another area, very important area, that the LRC is looking at in its review. There are 4 parts to it, to the review. First of all, for sexual behavior without consent, that is forced behavior such as rape or other or sodomy or other behaviors. Another would be crimes under the principle of protection, and that is the person involved will have to be of a certain minimum age. And third area of review is where public morality had been violated, such as behavior in public areas. And fourthly, penalty and the consistency of penalty. The LRC, exactly as Mr. Chan had pointed out, there are statutes where there is inequitable penalties. And this is also a very important area that the LRC is considering. Ms. Chan, as mentioned, concerning the statistics that I have talked about. Before the LRC can finish their review, there will not be any improvements to these penalties. Now, how long will we have to wait? Is it another 2 to 3 years? We've been waiting for 9 years, or does it mean another 10 years? Yes, I myself am involved in the subcommittee work of the LRC. They are actually starting from 2006. They have been working flat out, and they've had meetings on a monthly basis since then. The reason why it's taken so long is because there were, after 2 to 3 years after they started work, there were a couple of very important legal cases, and there was urgency in protecting the underage children. And therefore, if you remember, there were such incidents and such court cases. And that was in 2010, and in 2011 there was a register or name list prepared, if you remember. And after that, the LRC went back to the review work immediately after. And also, they have also looked at the criminal offense involving young boys. In the first report, they have suggested taking away 118A. And what is 118 about? That is anal sex before consent or without consent. Now, for homosexual sexual behavior, this is the one which is a kind of sexual behavior without consent. And when discussing this, the LRC suggested that 118A be taken off, deleted, and be replaced with another stipulation. So that is to say, so when will 118A be deleted, since they have raised this as a suggestion? Well, they have done the first round of consultation, and they have gathered a lot of opinions. They will have to go back to the administration with certain proposals. They have gathered a lot of written submissions as well, including those from the LegCo, and they have not forwarded them to the administration. As far as I know, they want to do so in a wholesale basis. So you are saying that 118A deletion will come to pass, and when was that? I think it was in September 2011 that the consultation paper was issued. So when do you estimate 118A to be deleted? Well, according to my understanding, Mr. Chan, the LRC review basically will take out all stipulations distinguishing the genders or sexual orientation. So in the future, there will not be male or female mention, but rather simply the penalty will be based on parties A and B, and also on the severity of the offense. So for sexual minorities and their needs, I believe that this very comprehensive review should be able to answer their demands. And this will be a platform for allowing the public to understand the import of all the proposals. And also there will be immediate follow-up from our part. And we have been very good. For the name list, for instance, after it was prepared, within 1 year it was enforced. So we did not wait for any budget or any approvals, basically, but we have immediately followed up, and in batches. Mr. Chairman, I do not question the direction of work of the LRC, but the time taken is just unreasonably long. As mentioned just now, 118A deletion was proposed as early as 2012, but when I pressed, the administration was not able to give me a date for it coming to pass. Now, for this particular statute, there is a structural inequality to the sexual minorities and to certain persons. Apart from sitting on our hands, what else can we do, or what can the government do, may I ask? Mrs. Ng? Mr. Chairman, thank you for the question. During this period, we will continue to participate in the subcommittee work of the LRC. The review work of the LRC is honestly very comprehensive and serious and detailed. They've been referring to reforms in overseas jurisdictions, and we have provided information, the UK, New Zealand, Australia, etc. And through the participation of different individuals such as judges, senior barristers, academia from the sociology and other disciplines, social work disciplines, everybody wants this to be introduced as early as possible. And the LRC, in response to the Committee for Justice, they also made it clear that they want to, as soon as possible, come up with the second consultation paper. Mrs. Ng, in that case, can I ask you, by 2017, do you think 118A will be dealt with, its cancellation, that is? Disregard the second or the third consultation paper. Mr. Chairman, as I've mentioned just now, the review is highly complicated, and there are a number of considerations therein. And the LRC had already responded to the legal panel, and they were unable to come up with a concrete timetable. But because we know the framework of their proposal and suggestion, therefore internally, we have started work to see how we can follow very closely the work of the LRC. No, there is no timetable for coming up with their proposal to the government, but in the meantime, we are trying our best to keep very close and with their work in terms of internal studies and in terms of notifications to the police enforcement officers. Well, Mr. Chairman, I want to know, I mean, if this is the LRC, then there's not much we can do but to sit on our hands. Is that not right? If it were left to a department, at least we can put pressure on the department for speedy processing, yes? Right. Well, anybody else? Questions? No? Yes, our legal advisor. Thank you very much, Mr. Chairman. I'm looking at part 2 concerning criminal offense amendments. These are based on court judgments where the court had ruled that the statute is actually unconstitutional. There had been follow-up, and one of which is 118J. According to the stipulation 6, only 118J bracket 2, bracket A will be deleted. But if we look at the draft, it also mentions the deletion in total for 118F bracket 2, bracket A. And we have asked that question of the administration, and they have responded, and we have tabled their response. Our question was, why delete 118F in whole? Well, 118F1 had been construed as unconstitutional, and the administration, after looking at it, believes that 118F1 should be deleted in full. As for 118J, because only A of 118J had been ruled unconstitutional by the court, therefore only A part is to be deleted. However, if we look at 118F and J, they are very similar. And if we look at the rationale of the court's judgments, we believe that 118J, if indeed is unconstitutional, why is 118F to be deleted only in part? I mean, I wonder whether the administration has already looked at the Supreme Court ruling, and whether they have come to, therefore, the conclusion that 118J1 is constitutional and not 118J2. And secondly, concerning the Commodities Description Act, it was also because of the Court of Final Appeal judgment. I believe it pertained to 26(4). The administration also looked at other similar stipulations and statutes to see whether there were further room for amendment. So in that same principle and spirit, I would like to ask whether, given the treatment for 118F, whether 118J should be treated the same.
No.
Mrs. Ng, thank you, Chairman. Thank you, legal advisor, for your comments. As I pointed out earlier, in this amendment exercise, we are handling provisions that are ruled unconstitutional by the court. If you look at 118J1, actually 118J and 118F are similar in structure. For 118F, we propose to repeal it because F1 and F2A were ruled by the court as unconstitutional in 2 cases. But for J, 2A was ruled unconstitutional. So we didn't propose to repeal J1. Even though we don't propose to repeal J1 this time, it's still in the review. The review is very important. As we discussed just now, the review is important because of the penalty. If you look at 118J, it's about serious obscene behavior between males, and the maximum penalty is 2 years of imprisonment. If there is not a comprehensive review, if that provision is repealed, then similar behavior will be taken up by another law in common law, and maximum penalty will be 7 years of imprisonment. So without a comprehensive review and consultation of the relevant bodies, this is not a desirable approach. So we propose not to do anything. There may be the chance that this may be challenged. Yes, legal provisions may be challenged in court, but we know that LRC is carrying out the review as soon as possible. And it is better to review also the sentencing or the penalty part. Mr. Chen, for this statute law, miscellaneous provisions bill, do members have the power to move amendments? Legal advisor, yes. So members do have the right to make amendments as in other bills, but then there will be the same restrictions. So about the scope of the bill and also the impacts on public money. So the same rules will apply. By motion. By motion or by what format? Chairman, this is a bill, so usually there will be CSAs. if members would like to move amendments. Chairman, I have a question. If I want to amend 118J, what would the government do? Will you just withdraw the whole thing, Mrs. Ng? Thank you, Chairman. Thank you, Mr. Chen, for your comments. We have explained why we have this consideration about 118J1. Okay, you don't need to answer each and every detail. I just want to know about the principle. If I move amendment, then what will you do? It depends on how you are going to propose amendments. LRC is working. Very soon, they will issue the second consultation document. And the second consultation paper covers this part as well. The minimum legal age for sexual behavior is involved. So there will be some proposals for public to discuss. So at this stage, if we work on individual provisions, if we consult the public on individual provisions, then we'll be duplicating work and the public will be confused. So we are proposing this, and then after a few months, LRC may propose something else. So we propose not to amend other provisions at this stage. Very soon, LRC will publish the second consultation paper. That will be a platform for discussion. It's also a review. Thank you, Chairman. Any other questions? Legal advisor? No? Okay. After discussing the policies, we can refer to the marked up copy. We will work on the English and Chinese versions together. Page 1, marked up copy 0001 of both the Chinese and English version. Mrs. Ng, will you take us through the amendments? Yes, thank you, Chairman. Page 0001118C, 21 years will be changed to 16 years. 118F, as explained just now, the whole provision will be repealed or deleted. And then on page 0002, 118H, it's a consequential amendment. 21 years will be changed to 16. And 118J, 2A will be deleted. Page 0003, it's related amendment. In Schedule 1 of the Criminal Offence Ordinance, there will be some related amendments. Schedule 1 is about some offences, and there may be other convictable offences in court. 0004, Schedule 2 to the Criminal Offence Ordinance, they are related amendments. They are extraterritorial provisions. What are they? There may be some criminals who may seduce some children to go out of Hong Kong and assault them in order to evade from legal responsibility. So there are provisions to protect children with extraterritorial effect. So this is a related amendment. 0005, under the police ordinance, there are some serious and arrestable offenses. So these are arrestable offenses. So there must be serious offenses before the police can exercise their power. For example, they can take body fluid and DNA from the suspects. But in minor offenses, these cannot be done. This is just an example. That's in 0005. 0006, the related amendment is in the Small Child Service Ordinance. So if certain offences are committed, the persons cannot take care of children. They cannot take up jobs taking care of children. 0007, custody of released offenders. When these offenders are released, how they should continue to be subject to monitoring and counseling. And then page 0008, Social Workers Registration Ordinance. In Schedule 2, there are a series of offenses. If these offenses are being committed, people who would like to be registered social workers will have to declare. And at the end of the day, the social worker registration authority will decide whether or not these people can be registered as social workers. Any questions? Legal advisor? No question about the English version? Okay, no questions. If there is no question, then let's move on to part 3. Part 3. Amendments to Sex Discrimination Ordinance. C1378 on the Blue Bill. Who would take us through the amendments? Mr. Zhang. In the bill, 13 to 41, the EOC from time to time review the discrimination ordinances, and they will propose amendments as necessary. And the government, together with the DFJ, have reviewed the ordinances, and we propose some amendments. I would like to take members through these amendments. There are 3 parts. Under the Sex Discrimination Ordinance, Schedule 5, there are some amendments being proposed. Schedule 5 is about exempted parts in the Sex Discrimination Ordinance. Because of updating in the law and policies, the Bureau is of the view that those provisions don't need to be kept. For example, if you look at Schedule 5, the male officers' positions will be kept, and in case if weapon is used, there will be the need for exemption. But these are outdated and can be deleted. In Schedule 5, there are 2 parts that are being repeated in the principal legislation, and we propose that these can be deleted in this amendment exercise. And then in Schedule 3, there are a few provisions that were added back then because some work needs to be taken up by male. And in Schedule 3, there are 4 rules: women and young persons industry regulations, construction site safety regulation. In these provisions, there are amendments already, so contents with referring to women have been deleted. So the whole Schedule 3 can be deleted. I'm referring to 14, 17, 18, 20, and 22. For 32 and 37, the reason for amendment is when EOC enforces the 4 anti-discrimination laws, well, they don't need to bear legal obligation if they are in good faith. These provisions are in Sex Discrimination Ordinance and Racial Discrimination Ordinance. And we propose that these provisions should also appear in Family Status Discrimination and Disability Discrimination Ordinance so that the provisions are clearer to give better protection. And then the text of the provisions will be updated. For example, the name of educational institutes. In the past, it's polytechnic institutes. Now we would like to change it back to a polytechnic university. And about disability discrimination ordinance, I will defer to Ms. Zhang. Thank you, Chairman. About the disability discrimination ordinance, there are 3 main amendments. First, there are some technical amendments to the Chinese text so that the English and Chinese text tally with one another more. And we have taken reference from the other 3 anti-discrimination ordinances and commonly used terms in other laws. And if you refer to number 73 about implementation notice of EOC, there are some omissions in the provision, so we would like to add them back. And the third amendment is to protect EOC members and staff. Thank you. Okay. Any questions, please? Legal advisor, any questions? If not, then let's read the marked up copy 0009. Who will take us through the amendments? Mr. Zhang or Ms. Zhang? Mr. Yao. Okay. Let me brief members on the amendments in Part 3 from 0009. Now, I am referring to the Chinese version, so some words are being updated so that the 4 anti-discrimination laws are in line with one another. And then in relation to the definition of employment, that is slightly amended based on EOC's recommendation. So the definition of employment will be the same in all 4 anti-discrimination laws. And we have taken reference from the English text so as to make sure that the definition is clear. 0010 and 0011, the same amendment is in them. 12G. For this amendment, as Mr. Zhang just said, we propose that because the rules are not applicable, so Schedule 3 can be deleted. So reference to Schedule 3 can also be deleted in this amendment exercise. And then 0012, as explained just now, Schedule 3 is referred to, so we propose to delete it. So reference is made to 12G, and 12G also refers to Schedule 3. So in that case, we propose to amend them together. And then 0013, about employment agencies. Please pause here. Legal advisor?
I'm sorry, a technical amendment. If we're looking at the page 12 of the Chinese version, 12.4 there, in the Chinese version, because the punctuation has to be deleted. In fact, it's appeared twice in the Chinese version. And I have already communicated this earlier, and the amendment will be made. Yes, indeed, the administration had said that they will see to that. Indeed, Mr. Chairman. The Chinese and the English version actually differ slightly, and the Chinese version actually refers to the same section twice. There was a repetition, and as the legal advisor had pointed out, we will make the appropriate amendment. Yes. And concerning employment agency, in the stipulation, we would want to make it more clear. For instance, in providing its service, we want to say very clearly in the service of the employment agency, rather than leave it unclear as its. 0014, similarly, in the same spirit, the amendment. And then we go on to 0015, which also refers to Schedule 3. And as mentioned just now, we will be deleting any stipulation referring to Schedule 3. 0016, similar. 0017, the first half basically refers to Schedule 3, and as mentioned before, we will delete any stipulations referring to Schedule 3. And as for the rest of it, in 0018, it refers to the protection. And as Mr. Cheung had pointed out, in the 4 pieces of legislation, we want them to be consistent in the protection afforded. And we basically want the content in these 4 statutes to also be consistent. And therefore, we have changed the wording therein to make them consistent. That's for the second half of 0017. And 0018, similar. And 0019, the name of the education institute, the colleges will be changed to universities as appropriate. And next we have Schedule 3 itself. And as we have mentioned just now, concerning the gender references, we have removed them. And therefore, we will also be taking away Schedule 3 altogether. And next, for the definition on technology procedure, in fact, this is in Part 4 of the legislation. In fact, we will be deleting Part 4 altogether. We propose that. So we do not need to have this here. We will delete it. 0023, concerning exceptional situations or exceptions. And that would be police tactical unit and certain reserving office for men in the police tactical unit, and that is no longer applicable. It is quite outdated, and therefore we will be, we propose to delete this. That's in para C and D of item 1 under part 2. Page 23 in the Chinese version in the schedule. And I'm looking at 23.3, and I'm looking at the format, which is in column form. And the first column, there are the numbers, and then the exceptions, and then the changes. And when we look at 23.3 for the column, listing out the exceptions, it is named column 2 instead of column 3. That is discounting the column with just the numbers. And if we look at the Chinese and English version, basically they are different in terms of the mention of the number of the column, and the body as well as the schedule also differ in that regard. Well, thank you very much for the legal advisor's view. For column 1, where the number of the item is mentioned, we will treat that as column 1. But if the number is not listed in that column, then it will not be treated as a column with a number, i.e. column 1. And that's been a time-honored way of treating this kind of content. And it will be difficult for us to amend the entire table. In fact, there are inconsistencies, but we will have to leave it for the future in making a wholesale amendment to this kind of discrepancy. To 0024. The third line. Concerning employment, definition of employment has to be updated, and this will be amended accordingly. And then items 4 and 5 are to be deleted because if this is a repetition with 56B and 56C, and therefore we will take this out here. 56B and C have already covered items 4 and 5. So we'll propose to repeal these two items. As for item 8, the Royal Hong Kong Auxiliary Police Force pensions regulations have been repealed in 1997. Therefore, item 8 has become obsolete and should be repealed. Yes, 0027. We are looking at the English version, person or associates, and them, those people. and also extending the EOC and its jurisdiction over these people. 0028, the amendment are basically the same with the other three discrimination ordinances. And basically the training contract, the term will be amended appropriately. And the Chinese version also is different from the English version in one of the words, and that will be amended accordingly. And also in the Chinese version, there is one character which is redundant, and we will be taking that out as well. And also, 203, we will make that consistent with the other three ordinances. And also, the person responsible will be looked at, will be amended, and 0035 will be amended to staff. And this is in keeping with the other two discrimination ordinances. 0036, as mentioned just now, some of the amendments will also be reflected in the other discrimination or anti-discrimination ordinances. 0037 refers to Clause 41, which will include Section 73. But a reference to Section 41 is missing in Section 73 regarding the latter's applicability, and therefore this will be added. And also we will be adding the Chinese name to the clause as well. Thank you, Mr. Chairman. That is all. Legal advisor, any questions from you, please? Mr. Chairman, I think there are some more. Oh, yes, indeed, Mr. Chairman. Yes, this is, there is indeed some more. 0039 concerning the employee, that will be, the definition will be made consistent. 0042, this definition is in Section 52, and because the definition is also mentioned in the other anti-discrimination ordinances, so we will put in the relevant definition as well. That's 0042. The employment agent will also be amended to the agency, and the 0043. The committee and staff protection is missing. We will put that back. 0044 on the definition of employment, that will be reflected accordingly. 0045 discrimination, racial discrimination, that will be reflected here. And 0046 Chinese version, one character addition to make it clearer, and 0047 also a Chinese version wording change with no change to the import, and we will basically make the wording and also the stipulation consistent. Any other questions, please? Legal advisor, yes? On the Chinese version, no? English version, none. Thank you. If there are no further questions, we go on. Well, we close part 3 discussions and go on to part 4. Paper 1415, who will introduce to us the policy intent. Yes, this is to amend 2 pieces of legislation. Now, according to Section 81 of the Evidence Ordinance, those who are legally retained can be brought in front of the court so that they can bring legal proceedings or serve as witness at the court proceedings. But in Section 81, it does not talk about the land tribunal and the legal profession or legal professionals in the tribunal. In Section 81(1) or the Lands Tribunal Section 10, basically they all mention clearly that these persons can be brought in front of the court to provide evidence or to make defenses for themselves. And therefore, we are of the opinion that amendments should be made to Section 81 of the Evidence Ordinance so that these professionals, the judge and the legal professional, will have this right in bringing these persons to the court. And in order to make sure that the two types or two categories of legal professionals have the same right in calling for incarcerated or detained persons to stand in front of the court. Therefore, we will also have to make the amendment to make sure that the powers of these two types of professionals, legal professionals, would be the same. Mr. Chairman, just a technical point from the legal advisor.
In the 2014 Competition Ordinance Amendment Bill, in Section 43 of this bill, Cap 8, Section 81 of the Evidence Ordinance was also amended. So if that bill is passed earlier than this bill, if it is gazetted earlier, then this part of the bill will have to be amended accordingly. We have communicated with the administration some time ago, and they will monitor the situation. Any supplement, Ms. Zhang? Yes, no problem. If there is no question, then we will read the marked-up copy 0049. Ms. Zhang, will you take us through the technical amendments? Yes, thank you, Chairman. 0049, Cap 8 of the Evidence Ordinance was mentioned just now. The Labour Tribunal Ordinance was crossed out. This is a textual amendment. So apart from Labour Tribunal, we will have to add in the Lands Tribunal Ordinance. So we need to add in the judicial officers of these tribunals. 0050, there's another consequential amendment in the Lands Tribunal Ordinance. We have to add in some phrases to say that no matter whether we are talking about the permanent or the ad hoc members, the powers are the same. So this is a technical amendment to clarify the relationship between the two. Any questions? If not, English version, any questions? No? Then let's move on. Amendments about acceptance of some instruments or documents. Part 5. Amendments for Part 5 are at the request of the Notary Public Association's request. So the High Court rules and also the District Court rules will be amended, and one rule will be added so that Notaries Public of Hong Kong will issue some certificates or documents, and in the future civil proceedings, these certificates or documents can be accepted as admissible evidence. There's not the need to have supplementary proof, but this is just prima facie. The two parties to the litigation can provide other evidences to overrule these rules. Okay, any other questions, members? If not, then 0051 of the marked up copy. So can you take us through the amendments? Members, on 0051, 52 and 53, the text is exactly the same. They only amend different rules. 0051 amend the High Court rules. 0052 amends the evidence ordinance. 0053 amends the district court rules. But then the text, the provision reads exactly the same. So we're talking about the same proposal, unless if there is a contrary proof, the notary public's documents or certificates can be accepted as admissible evidence. There is no need for supplementary evidence or proof. But we know that in the court proceedings, there must be some documents or papers as evidence. So the format of the notary public's documents must be such that there must be signature or chop of the notary public, and the notary public's behavior must be confirmed. And we also set out the definition of such behavior and notary public. Any questions? Legal advisor? On part 5, some time ago, we wrote to the administration and we asked some questions. So far, we haven't received any written response. Can the administration give a verbal response? First, if you refer to page 51 of the Chinese version, there is a newly added big 9A. And then there is a definition of notary public's behavior. And B sets out some points. These are not included in the definition of notary public's behavior. So can you explain why there is the need for these omissions? Thank you, legal advisor, for your question. So Section 10 of Oath and Administration of Oath Ordinance is deleted. And if we are talking about places outside of PRC, for example, if there's an oath administered in front of Consulate General of PRC, then the legal effect is the same as oath administered by authority in Hong Kong. So this is likely to include notary public. The purpose of this proposal is to facilitate the business of notary public in Hong Kong. So those instruments and documents can be accepted as admissible evidence. We don't intend to extend this to cover overseas notary public. But if you're talking about places outside of PRC, for example, if oaths are made in front of ambassadors or consulate general of PRC, then by that we mean overseas, and we have to state clearly that the scope won't extend to cover public notaries' behavior in other overseas or foreign countries. Any other questions? If not, any question in the English version? If not, then let's move on to part 6. Chairman, actually, the agenda today only covers parts 3, 4, and 5. For part 6, colleagues responsible for part 6 are not in attendance today. But since we still have time, can we work on parts 14 and 15 first? Because the responsible officers are here. Okay, parts 14 and 15. Let's turn to 1518, page 1518 of the Blue Bill.
好，第14部分。
Part 14. Part 14. So to standardize references made to officers of the Customs and Excise Departments. Ms. Kwok, parts 14 and 15 are minor and technical amendments. Part 14, basically, references to public officers in the CNED will be standardized. The major CNED officers, well, the references to them are not standardized. So we now want to amend these inconsistencies so that the whole piece of legislation will be more consistent. Now, sometimes there is the reference to Hong Kong in front of commissioner and sometimes not. And for deputy commissioner, there are few ways to refer to him. Deputy Customs and Excise Commissioner and so on. So we will try to standardize the title. And then about Assistant Deputy Commissioner. So different names or titles are given to this position. So this time we will make amendment to standardize the title. So 0133, page 0133, because there are quite a lot of subsidiary legislations and provisions being involved. So basically the words Hong Kong will be deleted. So Chairman, do you want me to explain them one by one? Or does our legal advisor have any comments? Okay, let's see whether members have questions. If not, then we can examine the clauses one by one. Okay, can you go through each and every clause? 0133 of the marked up copy, please. Yes. Cap 60, Import and Export Ordinance. Section 2 will be amended. So we will delete the words Hong Kong when referring to Commissioner for Customs and Excise. So that is the standardized way of referring to that position. And then there's another consequential amendment. In Part 2, Cap 68, Units of Measurement Ordinance. In the interpretation, in Section 2, Hong Kong will be deleted. And then for Sections 3, 4, and 5, we will make the same amendment. Hong Kong will be deleted when referring to the Commissioner for Customs and Excise. Section 8, 34, and 38, that will be the same amendment. So Hong Kong will be deleted in all these sections. There will be similar amendments to the other sections. Hong Kong will be deleted. And then Part 3, Cap 99 of Hong Kong law, Pension Benefits Ordinance. The nature and content of the amendment are as explained just now. Item 2 of the Chinese version, Hong Kong will be deleted. And Cap 99, Section 8, 34, 38 will also carry the same amendment. I think it's better for you to give us the page numbers as well. Okay. Chinese marked up copy. 0137, Part 4, Cap 99, Subsidiary Legislation C, in the Pension Benefits Ordinance, Department Head rank. So again, Hong Kong will be removed in the title of the Commissioner for Customs and Excise, page 0138. Page 0139. Immigration Ordinance, Cap 115. Again, the title will be changed. Page 0140 of the marked up copy, Deputy Commissioner. The title will be made standardized. The same amendment will also be made to another amendment carrying the same title. Cap 120, Public Revenue Protection Ordinance, will also be amended. Section 4, Hong Kong, will be deleted. 0142 of the marked up copy, Part 8, will amend Dangerous Drug Ordinance. Section 38B, C, E, Hong Kong, will be removed. 0144, 0145 of the marked up copy, 38F and 38G of the Dangerous Drugs Ordinance will be amended. Again, Hong Kong will be deleted. And then marked up copy 0146, 52, Section 52 will be amended. Again, Hong Kong will be deleted. (0149) of the marked up copy. In the definition of the Commissioner for Customs and Excise, again, Hong Kong will be removed. 0150 and 0151 of the marked up copy, amend 13A. Again, Hong Kong will be deleted. (0152), amend 53B and C in the same nature. 0153 of the marked up copy, Part 9, amends Cap 145, Control of Chemicals Ordinance. The same amendment will be made on 0153 in Section 2 in the interpretation part. That will be the amendment in relation to the Commissioner for Customs and Excise. 0154, Part 10, amends International Organization and Foreign Affairs Ordinance. And again, Hong Kong will be removed. Because the principal legislation will be amended, so the subsidiary legislations will also be amended consequentially. Part 11, Food and Agricultural Organization Ordinance will be amended. Hong Kong will be removed.
Part 12, concerning Cap 190, concerning the amendment as mentioned just now, and that is for the head of Customs and Excise. Now we are looking at the Chinese version, page 10156 of the Chinese marked up version. Because there are so many technical amendments. Yes, we're trying to follow. 0157, Cap 190, the Nuclear Power Committee. Again, it is a change to the name of the Customs Department. And next to the Aviation Department, again, this is about the title of the Head of Customs and Excise. And Part 5, and this is the International Labour Ordinance. Again, the change in title of the Head of Customs and Excise Department. And next, for the Asia-Pacific Maritime Produce, again, this is about the change in the title of the Head of Customs and Excise. Part 6, Cap 190. Again, it's the title change, as mentioned just now. Part 18, Cap 190, Section H, concerning the UN, again, the same title change. Page 0163, Cap 190, Section I, concerning the UNESCO, again, the same title amendment. Part 20, page 164. Again, it is the same title change. It's page 0165 concerning Cap 190, Section K. Again, the same title change. Page 166, Cap 190, Section L, the same title change. Page 167, Cap 190, Section M, the same title change. Page 168, Cap 190, Section N, the same title change. Page 0169, Cap 190, Section P, stipulation, Clause 6 there, same title change. 170, Section Q of Cap 190, the same title change. For Part 27, it is Cap 191, 4E there, the same title change. Part 28, for Commodities Ordinance, for Clause 2, definitions, the same title change. And also the Deputy Head of Customs and Excise will also be amended accordingly. We go on to the next page concerning the garment industry. We will delete any mention of Head of Customs and Excise, and in the Schedule 1, the same title change. Part 30, Cap 324, concerning origin of production. We will delete any mention of the title, Head of Customs and Excise. Customs and Excise, Cap 342, you see that the main officers' titles, we will amend them accordingly, deleting all mention of Hong Kong. And also, we have included a new Clause 2. We have mentioned here that in the Hong Kong law, these few titles were mentioned differently. And here we put in a transitional clause, and that is before the effective date of this statute, if there are any proceedings with the old title, the new title will take place because the Customs and Excise is continuing to operate, and there may be documents, etc., letters that they may be issuing, and we just want to make sure that there is nothing that falling in between. I'm sorry, I just want to know, Mr. Chairman, why is there are there such changes to the title? I do not know the difference between the two titles. And that's why we have all these changes. What is the consideration there? Would you please explain? Ms. Kwok. Mr. Chairman, yes, the head of for Chinese, and indeed the head of Customs and Excise was called 海關關長 before, but there was a period of time when the 海關關長 was changed to Hong Kong or 香港海關關長, and therefore the discrepancies. So there is an additional mention of Hong Kong in front of the title, and we want to make all the titles or mention of the titles consistent by deleting Hong Kong, quote unquote. So this is really technical, and we have just a few of these changes that we have to make. Well, apart from the head of Customs and Excise, what about the commissioner? Apart from the commissioner of Customs and Excise, what about the commissioner of police? No, there is no such problems with the commissioner of police. In fact, the moment we spotted this discrepancy, we have gone to the commissioner of Customs and Excise, and they have no problems with it, and therefore we are making these amendments. The commissioner of police, there is no Hong Kong commissioner of police anywhere appearing, is that right? In the schedule, let's say, for instance, which schedule are you referring to, Mr. Chairman? Concerning pensions? Right, I'm checking. The yes, page 137. If we want to be absolutely accurate, we can go through one more review and provide a supplementary paper afterwards. Because of the basic law, is it because of the basic law we have to change the laws? No, that's not at all. It's just that in the Hong Kong laws, we have always used the Commissioner of Customs or the Hong Kong Commissioner of Customs. The basic law basically just followed the Hong Kong statutes. So it is not because of the basic law that we have to change. Well, the Commissioner of Police is called the Hong Kong Commissioner of Police, isn't it? Why are we deleting Hong Kong from the Commissioner of Customs and Excise? Well, Mr. Chairman, I have to confirm whether the other titles, such as Commissioner of Immigration and Commissioner of Police, do not carry the word Hong Kong, or the words Hong Kong. But I want to be 100% sure. I don't want to mislead anybody here by just providing the information offhand. We will go back and check in thoroughly and come back with a response. I just want to know when we have started with this new way of putting this title, Hong Kong Commission of Customs and Excise. Well, Mr. Chairman, we've gone through a few rounds of amendments, and there had been an adaptation to the titles, and there were certain changes to certain titles during that period. As for the Customs and Excise Ordinance, because it was a very long-dated ordinance, it was originally in English only, and after that we came up with a Chinese translation of the ordinance. And where we find in our department that there are any discrepancies, we will try to, as soon as possible, make the relevant amendments so as to make them consistent. Yes, they do stand out like sore thumbs for us. So you're saying it's just the Commissioner of Customs and Excise and not so for the other departments, is that right? What about the LegCo, the Legislative Council? Have we ever been referred to as a Hong Kong Legislative Council? Well, probably not. Yes, indeed. Thank you. The 0178, page 178. Yes, part 32, cap 326, commodities description. Ordinance, again, the change in the title, deleting Hong Kong. Sometimes you delete Hong Kong and leave the Commissioner of Customs. And sometimes you delete the entire title, including the Commissioner of Customs and Excise, and then add in the Commissioner of Customs and Excise. Why is that? Well, this round of amendments basically only deal with the three titles. We try not to change the context at all and basically effect the amendments as efficiently as possible. And where necessary and where appropriate, we will delete only Hong Kong. And for some other statutes in the Chinese version, where the deletion of Hong Kong would not make sense, we will have to delete the entire title and to add it back somewhere else. So it really depends on the wording of the statute and the context. And basically, we do not want to change anything in the statute except for the title. I'm looking at page 179. You are deleting the entire title and then adding back in the title. Why do you not just delete Hong Kong, the two words? Because it talks about the schedule, and if we delete Hong Kong only from the Chinese text, because it talks about the document number 78, if we delete only Hong Kong, it would be unclear. Yes, just a point of supplement from our legal advisor. If there is another place where Hong Kong is actually mentioned in another part of the statute, we cannot just repeal the two words or delete the two words Hong Kong. Oh, so this is for avoidance of confusion, is that right? Lest people do not know where the two words Hong Kong are to be deleted. That's right.
Thank you, legal advisor. 0180 amends Smoking Public Health Ordinance. Section 10A, 2 will be amended, Hong Kong will be deleted. And then number 4, again, the title, same title change. 0182, Part 35 of the marked up copy, amends 371, Cap 371, Subsidiary Legislation B. Sections 3 and 4A, we will make the same amendment on title change. 0184 of the marked up copy amends 4AA of the subsidiary legislation, the same title change. And then page 0185 amends 442, Toy and Children Product Safety Ordinance, same title change. So Hong Kong will be removed. Page 0186 amends Cap 442, Administrative Appeal Board Ordinance. Schedule 30. Hong Kong will be removed. 0187, Part 38, Consumer Products Safety Ordinance will be amended. In the interpretation clause, there will be the same title change for the Commissioner and the Deputy Commissioner of Customs and Excise. Part 39, amends Cap 526, and you can see that in the definition of Commissioner for Customs and Excise, all references to Hong Kong will be deleted. Part 40 amends Cap 537, Subsidiary Legislation B. In the definition of the Commissioner, all references to Hong Kong are deleted. Page 0190 amends subsidiary legislations A and C of Cap 537. All references to Hong Kong are removed. 0191, Part 42, amend subsidiary legislation A and E of Cap 537. All references to Hong Kong are removed. 0192, Part 43, amends subsidiary legislation AF of Cap 537. All references to Hong Kong are deleted. 0193, Part 44, amends subsidiary legislation AN of Cap 537. All references to Hong Kong are removed. 0194, Part 45, amends subsidiary legislation AR of Cap 537. All references to Hong Kong are removed in the definition of the Commissioner. 0195, Part 46, amends subsidiary legislation AW of Cap 537. All references to Hong Kong are deleted. 0196, Part 47, amends subsidiary legislation AX of Cap 537. All references to Hong Kong are removed. (0197) Part 48 amends Cap 551. First of all, in the interpretation part, we have added the definition of the Commissioner for Customs and Excise. Now, in this ordinance, there is no such definition. So when the Commissioner is referred to, it states Customs and Excise Commissioner. And we have discussed with the Commissioner. He's of the view that it is more appropriate to include a definition so that in later text, there is not the need to repeat the title. A simpler way or an abbreviated reference, Commissioner, can be used. So in subsequent sections, we will say Commissioner because Commissioner is already defined. Commissioner is equivalent to Commissioner for Customs and Excise. Okay, Mr. Liu Chang-Kong. Hong Kong Customs and Excise Officers Children Education Trust. Is this the registered name? Do you mean whether this fund is the name of the registered fund? Yes, we have to talk to the customs because here the reference to Hong Kong is not removed. So I want to know whether this is because the name is being registered. Thank you, member, for being so detail-minded. Because this time we are trying to amend the title of the main officers. So we often say Hong Kong Customs. So we will review this with the department later. But all these parts are being reviewed by them upon drafting. Since they haven't given us any comments, we believe that there is no problem. But in order to play safe, we will review these parts with them again. Please continue. 0199 of the marked up copy, Part 49, amends Cap 557. So again, the same title change. Page 200 of the marked up copy amends Cap 558 subsidiary legislation A. In section 4, there will be the same title change. Page 0201 of the marked up copy, Part 51, amends Cap 578. In the definition of the Commissioner, again, all references to Hong Kong are deleted. Page 0202 amends Cap 615. Here, Hong Kong will also be removed in the title, in the Commissioner's title. Schedule 1, Part 2, in the definition of the Commissioner, all references to Hong Kong are removed. Part 53, in 2013, there is the legal notice 145. Again, in the definition of the Commissioner, all references to Hong Kong will be deleted. That's in Part 14. These amendments are about title change for these officers in the Customs and Excise Department. Okay, thank you. Any questions with the English version? Then should we move on to part 15? Who is responsible? Ms. Kwok. Blue Bill 1574, C1574. Part 15, Miscellaneous Amendments. The last part will deal with technical amendments. These are minor in nature and there is no policy impact. These amendments cover different ordinances. And before we work on any statutes, we will take reference from recommendations from policy bureaus. And after consideration, if we think that they are suitable for the scope of this bill, we will include them. So that's a brief explanation of Part 15. Okay, then let's examine the marked up copy. 0205, Part 15, 1. Amends Cap 3. And then in Section 2.1, Chinese version, in order to make the text more consistent, we will make this amendment. Because subsection 1 and 2, if you compare the text, there is some inconsistency. After this amendment, subsection 1 and 2 will be more consistent. There is no change in the content. The amendment is only textual in nature. Okay, so you just make these changes since there are the related changes in other parts. Okay, no question. Then let's continue. Part 2, amends High Court rules. This amendment, actually all the amendments in Part 15 have been discussed with the policy bureaus and they have checked the amendments. There is no problem. For this part, we want the Chinese version to better reflect and more accurately reflect the English version. So the paper has been read in the court and it is being referred to in the court. The original text is not easy to understand. Now, with the amended version, it's easier to understand and it's clearer. For the English version, there is no change, because we mainly changed the Chinese version so that the Chinese version is more in line with the English version. So again, there's no change in the English version in the other section. That's true. Yes. Okay. 207. 207. Legal amendment and reform integration ordinance. So we will change the deceased to the injured. 20C. The deceased is changed to the injured, and then after that, we'll say the date of the litigation and also the injured. So the same change will also be made in the subsequent text. In 0210, Part 4, amends Cap 91B, 0210 on the marked up copy. That's a technical amendment. Next to Schedule 3, there's a bracket next to Schedule 3. 8A 13 14, we will change it to 8A 13 14 and 16. What's the use of that bracket? It is to make it convenient for the public to know which provisions refer to Schedule 3. And if we read the provisions in Section 16, Schedule 3 is referred to. So that's why we have included 16 here in the bracket. Then page 0211 of the marked up copy, appeal hearing date is changed to the start of the appeal, the start date of the appeal, to make things consistent. Part 6. Part 6, Immigration Ordinance, 17C, 17B1B2, B2 in the definition of identity document. This reference can better reflect 17B2. That part is about the definition of identity document. The original reference may not be as accurate as the amended one. So this is a technical amendment. Part 7, Public Health and Municipal Ordinance. 1.3 is being deleted, and so only Part 1 is left. And then only Part 2 will be left as well, because Parts 3 and 4 have been repealed already. So there's the need to amend the legal text. So only Parts 1 and 2 will remain. 3 and 4 will be removed. How long have they been repealed? Long time ago? You mean Parts 3 and 4? Quite some time already. This time we want to group things together, because the reference appears in one ordinance. If this reference is to be changed, then we need a bill. And if that's the case, if we use one bill to make this amendment, it is not cost effective. So if these amendments are omitted, then these amendments will be dealt with by way of miscellaneous provision amendments. Then, page 0214, Part 8, subsidiary legislation of L of CAP 511. So again, the Chinese version will be amended to better reflect the English version. Page 0215, Part 9, amends CAP 159. Hong Kong Tertiary Institution Alliance will be removed. This alliance has been renamed already, so we want to update the reference to make it accurate.
Page 0217. This is a format change only, and after consideration, we feel that this is nothing but a format amendment, and therefore we propose the amendment also here. Any questions, please? Yes, anybody? Ms. Chang. We're looking at CAP 159A. This is with regard to the barristers in Hong Kong, and we believe that there may be actually perhaps a documentation or a typo here, actually. Typo here. Basically, there should be a line or a space for signature for the barrister concerned. And I do not know why this signature part was also contained in this blue book. And that's very strange, as though the judge at the Court of Final Appeal, or the head judge in the Court of Final Appeal, will have to fix a signature here, which is not true, not right. So you're saying that all these years the register of barristers requiring the Court of Final Appeals judge signature is erroneous? Well, there has never been a policy for the Chief Justice at the Court of Final Appeal to sign for any name to be added to the register or the barrister list. But actually, there had never been any such requirement in the law that the CJ will have to sign or give approval. But this is only in the format, in this particular form only. So it's never been required. So the registrar will continue to keep the register of barristers. Is that right? And that is correct. Yes, in fact, there is no change to the work. Yes, the registrar will be able to do so. Yes, Mr. Chairman, I need to actually declare interest. We four here in the room are all legal professionals, and we are on the list of this register. Well, I would like to know whether this is following the UK practice. I'm also a UK qualified barrister. The Master of the Rolls in the UK, which is a very senior judge, will have to sign. Now, the Master of the Rolls is the roles of barrister and solicitor. So basically, the senior judge will have to approve anybody entering into the register of barrister or solicitor. I do not know whether this is following the example of the UK system, whether indeed that it is necessary for there to be a Master of the Rolls or senior judge in approving the register. Well, the reason why there had been such a change was not because of a UK president, but rather in Hong Kong, it's always been the registrar who had been keeping the record. In the UK, I know that there is a rolls. There's actually a book. As for the approval, it has always been the job of the registrar, and it's never been our intention to ask a CJ to do that every time there is an entrant into the register. Can it be because of 1997 that there were certain changes to the legislation? Because before 1997 there were no such changes, no such title. There's no intention of downgrading anything. It's just an error. Yes, if there's any downgrading, it's ourselves downgrading ourselves. Yes. What about the solicitors? Is there a similar mistake in the register of solicitors? Yes, in fact, the moment we spotted this anomaly, we checked with the solicitors. No, there is no such error. Page 218. Cap 177C. This statute, or this part of the statute, had already been actually has lost its effectiveness and should be merged with 177G, and therefore this part should be taken off. And cap 331, the next page. In fact, there is a typo. Instead of referring to section 12, it should refer to section 11. Page 222, District Court. The English version actually talks about Schedule 2. And in the Chinese version, Section 79, we will reflect that meaning mentioned to the Schedule 2. And the next amendment, District Court, again, similar to the previous amendment. The amendment is to have the Chinese version reflect more closely or accurately the English version. For 14A, for District Court and High Court, they are the same, and therefore in 336H we make a similar amendment. Question? Now this is with regard to public court, where a document had been read out this public court, in the English version, it is termed court. In the Chinese, it may mean open court or public court. We look at the English version, page 138. It says, in open court. In open court, as opposed to in chamber. And those read out in chamber would not be caught in this particular statute. Is that right? That is the intention, is that right? To apply to such documents in the English version, to apply to or read to in open court, or let's say in chamber, if a document had been read to the judge in chamber, is that deemed read to court? And is that different from the open court or read to open court? Ms. Kwok? Well, actually, concerning the operation of this, I will have to go back and refer back to you and give you a response. Well, actually, Mr. Chairman, this happens all the time in the court, whether a document is read out in the open court or in chamber to the judge. The consequence is very different. I think 14A perhaps should reflect this. Well, indeed, we're only making technical amendments here. As for your point, I think I will have to go back to find out whether it is the open court or in chamber. I think we will have to refer this to the Justice Department for their response, and we'll come back to you. Well, given the time, and given that we have a few parts unfinished, we should stop here. Page 0223 in the Chinese version, and in the English version 2138, and we have parts 11, 12, 13, and 14. And also part 6. These we have not dealt with yet. Yes, we will leave that to the next meeting. And would you please invite representatives from all the relevant departments? If there are no objections, we'll close the meeting here now.